Good evening. This is Laws 11046, Law and the Environment. It's week number 5, and I'll be commencing my commentary from Bates, Chapter 4, which is really week 4 material. My apologies. Just a quick note about the examination. The exam will be based very much on the Bates material. That's not to say that you can't read the study guide material of the modules. That's very interesting and informative. But if you wish to simply get by the exam or even do well in the exam, my suggestion is that you know the Bates commentary very well. I think also it's a good idea to do past exams, maybe split into study groups in that regard, and that will serve you well. There won't be any great surprises. If you know Bates, if you know the material, you should be able to recognise the questions and give the answers a good shot. All right. Now, Chapter 4 of Bates deals with international environment law, and this is all under the general heading of the nature of environmental law. As usual, I'm going to guide you through commenting on the written material, and I'll start with 4.2, which is on page 97. Excuse me for reading passages, but it's the best way, I think, to focus, and it gives you an idea of how I go about reading the material and gives you an idea of what I think is the most important parts. So 4.2, the main difference between domestic law and international law is that participants in international law are countries, referred to as states, rather than individuals or corporations. I guess that's fairly obvious. But international law is therefore very much about the relationship between nations. The form of international law is, this form is known as public international law, as opposed to private international law, which governs the international relations of individuals and corporations with each other. Perhaps the most common form of private international law can be in relation to family law, where we talk about referencing the Hague Convention, which deals with the issue of international relations and international family law. Right, so lower in the paragraph, in municipal law, the sources and contents of law are usually well defined, and the administrative and regulatory institutions usually have clear and enforceable powers. But the sources and content of international law are more variable and often more difficult to discern. So therefore, it is harder to identify what is international law. 4.3, engagement of countries, particularly developing nations, in agreeing to international law is, of course, quite different to domestic legal engagement, where citizens effectively have no choice but to comply with the law. The other major difference from a domestic perspective lies in the fact with who makes and who enforces international law. The government may be answerable to the international community for its conduct in this regard, but international law will have no direct force in this country until enacted into domestic law by the Australian Parliament. And the reference there is Minister for Immigration and Ethnic Affairs against Teo. That's a 1995 High Court decision. You can tell it's a High Court decision because it's a CLR, or Commonwealth Law Reports reference. A breach of international obligation is not, for that reason alone, enforceable in Australian courts. So what we can say from that is quite simply this, that if Australia had become a party to a treaty which deals with environmental law, but the effect of that treaty had not been enacted through legislation, then it is not technically law that can be relied upon by an individual litigant in a court case as being legally binding, even upon the Commonwealth. It might be regarded as persuasive. It might be referred to in terms of understanding a general principle, or better explaining legislation that has already come into existence. But if the law has not been passed domestically, it is not regarded as law in Australia as such. At 4.6, international law is not just contained in treaties. It's also contained in general principles and customary behaviour of nations. So when we talk about the sources of international law, we're really looking at paragraph 4.7 onwards. And they might be regarded as divided into hard or soft law. An example of hard law is an international treaty or convention. There are, however, international principles which are accepted as law because the international community recognises these principles have evolved into law through customary acceptance, or because they're principles that should be accepted by civilised nations. I mentioned the Hague before. That is where the International Court of Justice is housed, and many declarations are made which are regarded as international law. And again, this is international law which is binding between states, not Queensland, New South Wales type states, but states as in nations. Soft law comprises principles such as sustainable development, and these are gaining increasing recognition and acceptance, but they're not yet said to have attained hard law status. And a good example of that it may be the precautionary principle. And you will see further comments made about the precautionary principle in Chapter 7. I'll just give you a couple of exam tips. I would suggest that you understand and know something about the doctrine of separation of powers, and I think it would be a good idea to know something about the precautionary principle. All right, let's move on at 4.9. The traditional sources of hard international law are contained in the Statute of International Court of Justice, Article 38, which provides that in deciding disputes before that court, judges are to rely upon four things: international conventions or treaties, international customs, general principles recognised by civilised nations, and judicial decisions and teachings of the most highly qualified publicists. That's a little different to the way in which law is considered by judges domestically, but there are some parallels. The first is international conventions and treaties. That might be regarded as akin to legislation. International custom and general principles might be regarded as akin to common law, as is judicial decisions. A big difference is that the court will consider the teaching of publicists. That's not directly regarded as law in, say, Queensland, but that's not to say that there isn't reference made to publicists in domestic cases. There often is, but it's not technically legally binding. It's officially someone's opinion about what the law is rather than the law itself, if you can understand that subtle distinction. At 4.9, these things don't bind individuals. That's a point we've made already. Although in a domestic law setting, they may be used to interpret domestic laws or otherwise influence domestic decision making. And again, I made that point before. All right, so let's talk about these different avenues or sources of law that are considered by the International Court of Justice in the event of an international dispute. So the first one is international conventions and treaties, and you'll see the commentary there in 4.10. Bates makes the point that these are the most common and straightforward of the various sources of law. They are agreements reached between nation states to regulate particular activities. They may involve a number of states, multilateral, or a few, maybe even two, bilateral agreements. But they are, in a sense, internationally legally binding. They do tend to be reactive, though some precautionary measures, for example, do creep into some treaties. Kyoto's mentioned there as an example. Once an agreement is reached, and the particular convention is open for signature and ratification, nations can then choose to be bound by the convention, not by their signature, but by an act of ratification. So in Australia, it is the federal government of the day rather than Parliament which makes the decision to ratify a treaty. That seems a bit odd, talking about the difference between the federal government and Parliament, but the difference there is really the difference between the executive, and I'm talking here of separation of powers again, which is the government itself, and Parliament, which is the source of the making of legislation, if I can use that term. So in terms of the ratification of and adoption of treaties, that can be done through the federal government. I'll get you to move on to 4.12. Environmental treaties are more like a framework, are more likely to be a framework treaty. A framework treaty concludes that general principles are made where the parties are bound, but leaves open to further negotiation the precise details, and those further agreements are then outlined in a protocol. In domestic legislation, it's a bit like an act as opposed to regulations. So very often an act will prescribe that certain things must happen or must not happen, but the actual detail is contained in the regulation. So we'll see that, for example, in things like the Transport Operation and Road Use Management Act will declare that it is an offence to speed, but you might look at the regulations, which will be more specific and provide the detail about what speeding is meant in different circumstances. So that's from an international perspective, that's like the difference between treaties and protocols, acts and regulations. All right, so the second source of international law is at 4.14 and onwards, and that is international custom. So that's the second source, and it's essentially unwritten but generally accepted international practice on a particular matter. The concept of good neighbourliness, for example, which postulates that even when a nation is acting within its legal rights, it should take account of the rights and interests of its neighbours, is widely regarded as a customary rule of international law. Now, treaties often formally define and develop customary rules. On 4.16, opinio juris, so a little bit of Latin for you. I'll just stop there. Law was, when I started studying, littered with Latin, if you like that alliteration, but that's become less prevalent now, and we tend to steer clear of the Latin terms for the sake of them. But Bates does refer to a Latin term here, opinio juris, which is the mental element that must, in addition to state practice, be present. And that translates to a sense of legal obligations that neighbours should behave in a particular way reflected by state practice. The third source of international law are the general principles, which are recognised by civilised nations, and you'll see that commentary in 417 and 418. And then finally, judicial decisions and the teachings of publicists is the fourth source of international law. Any questions so far?
Just one, John, in regards to, I guess, all international law, especially in situations that occur on the open sea, such as, I guess, piracy or sea shepherds, that sort of stuff.
Yeah.
It's interesting when they remove them from those areas, do they then become, so someone gets, for example, a fellow in Russia, the Australian fellow who was captured from the Greenpeace ship and taken to Russia. As soon as they move into home territory, so Russian territory, are they then legally bound by the country's laws and it's no longer international?
Yes, once they're into the national waters and they're outside the international waters, they're governed by the national laws of the state in question. So it can have a bearing.
Those states can actually take them from international waters into their own.
Oh, I see. Well, I'm not sure I'm sufficiently qualified to answer that question. I'm sorry. I don't.
It just seems to me that there's a good neighbourly issue there.
Yep.
If you actually take someone from international waters to your home national waters to then charge them.
Yes. I mean, it's hard to accept, isn't it, that principle that you can be nabbed and brought back in, almost like a forced extradition without trial. But does anyone else wish to comment on that or can provide an answer to Nicole that I can't? All right. It's interesting you raised the issue of piracy. Yes, Lawrence?
I thought it might have come under the United Nations Convention of the Law of the Sea, but it doesn't do that, does it?
Look, it may, but that would be the first place I think we'd go looking, but I don't know the answer offhand. Sorry. I'll just make a comment in relation to piracy. And of course, many of you may have seen the recent movie Captain Phillips with Tom Hanks, which was very interesting and thought-provoking. I had a discussion with my older son, who did some postgraduate study and research work at University of Queensland. His particular interest was in human trafficking. And I raised with him the issue of piracy and from an international law perspective. And he raised an issue which I hadn't considered, and that was theories in terms of the Somali piracy having established itself through breaches of international law where foreign states to the Somalis had come in and fished out the domestic fishing areas of Somalia in circumstances where there was no state that could take them on in terms of a cohesive effort through International Court of Justice, and that the piracy originally started as a result of individual fishermen who were aggrieved seeking redress from people that were alleged to have been breaching international water fishery legislation and customs. And then it became a burgeoning industry as a result of that. So it was an international perspective. I'm not teaching that in terms of being authoritative, but he did kindly provide me with some reading material, and he was at pains to say that this is not something which is accepted necessarily, but it's just a theory. It's something to consider. So I won't go any further than that. And I'd ask that you please don't quote me in terms of providing authoritative detail in that regard. But it was an interesting perspective. All right.
Unfortunately, John, I've had first-hand
yes,
involvement in a Somali piracy situation.
Oh my goodness!
They certainly don't they convene all international laws.
Oh no, and I'm not suggesting that in any way that it's appropriate or right. And what I'm just suggesting is that the scale is now, or has been, well beyond anything that might be regarded in any way as justified. I hope that assists, Nikki.
Yeah, no, it's just as any of the Western countries have absolutely no control or say or ability to be able to do anything once you get into a country that has no actual domestic law, let alone international law.
Yes. I think in the commentaries that I did read, I think it was widely accepted that Somalia was probably the most extreme example of a failed state in a domestic and international level, and it's probably right. All right, well, I might move on then to deal with matters of compliance and enforcement. That's 4.20 onwards. Enforcing legal obligations in international law is naturally more complex than in domestic law. There is no world environmental regulator to take countries to court and prosecute them. Acceptance of treaty provisions and consequent compliance also tends to be easier where a nation has no particular economic interest in the subject of the treaty. It is possible to claim compensation for environmental harm. For example, that was done through the United Nations Compensation Commission in relation to Iraq's unlawful invasion of Kuwait. So that's, some interesting comments there. Firstly, enforcement is much more difficult. It strikes me that in many ways the international law is where we were at domestically, not only in this country but in other countries such as the United States many years ago, where there was almost a Wild West mentality while we were trying to establish laws. People taking law into their own hand, vigilantes, the old Wild West in dealing with things on the spot, as it were. So it's a bit like that from an international perspective. We've got much work that needs to be done. 4.22, when breaches are detected, there are likely to be a number of stages through which compliance is sought. The first is through negotiation. Might be regarded as a soft option, says Bate. Bates. But more formal dispute resolution processes may involve mediation or settlement. The mediator has no power to order resolution of the dispute. I'll just stop there. Mediation is a form of what we call alternative dispute resolution. It's used, of course, in an international context, but it's also used very widely in a domestic situation. And a pure mediation is one where the mediator acts as a facilitator in an attempt to assist the parties to come to their own resolution, but in its pure form has no power to make any orders, and indeed has no power to make even suggestions. That's in a pure form. In the more invasive, but I think probably better form of mediation, there's still no power to make orders, but there is power to intervene and provide suggestions and undertake some techniques like reality testing. So that's mediation. By contrast, judicial settlement represents a solution that is binding on the parties. Conciliation is a sort of halfway house where the conciliator can make suggestions but not impose them upon the parties. Binding on arbitration, and this is 4.23, is a form of binding settlement. And there's reference in the material to the case of southern bluefin tuna, which was Australia and New Zealand against Japan, 2000, in which the tribunal prescribed provisional measures outlawing experimental fishing programs for stocks of tuna, which was once again based on the precautionary approach. At 4.24, where harm to the global commons occurs outside the sovereign jurisdiction of any particular nation, such as on the high seas, or to global climate, the question arises whether such harm is actionable, and if so, by whom. We might move on. 4.25 deals with the concept of sovereignty, and I'll simply highlight what is said in Bates. Sovereignty is important because it's a recognition by other nations of the right of a state to exercise exclusive legal control over the landmass of airspace above and waters adjacent to its territory. A little bit as we were discussing there before, Nicole and Lawrence, and there is reference there to the United Nations Convention on the Law of the Sea. Moving forward, now does anyone have any questions, any comments that they wish to make about what we've discussed? All right, we might move on to 4.30, and the heading there.
John, just one in regards to Q8 and the discussion on that. It would seem to me that the judgment tends to fall in the favour of winners of the dispute if it becomes a war situation.
Yes, are you sort of referring to the concept that history is written from the perspective of the winner, almost?
That's correct, and it appears to a degree that law is written, international law is written on that same perspective.
Yes. I must confess, and I do have this concern, that in international law there is not a common bargaining ground. There is an imbalance in bargaining position, and I'm not sure to what degree that is appropriately reflected in international law. I'm not saying it's wrong, but I think that's something that needs to be considered. Thanks, Nikki. Any other comments or questions?
Yeah, John, basically, though, what you're saying, though, is with regard to international law, that to comply, it's compliance by guilt. It's up to others to, there's no actual big stick which is there to force you to comply, is it really? It's just generally, you've done the wrong thing and you've got to try and fix up your stuff up, so to speak.
Yeah, generally speaking, I think that's right. I mean, obviously, we have the United Nations, we have resolutions that might be passed, we have requests for weapons inspectors, etc. But sometimes a state or group of states choose to take their own action, and that may even be contrary to a United Nations resolution. So, as I said, without wanting to diminish it or make light of it, in some ways we're still at that embryonic stage of trying to resolve international law in terms of binding legislation and recourse to resolutions, a bit like the Old West.
Yeah. Okay.
All right. Environmental rights as human rights, 4.30. In some countries, environmental protection is delivered more through human rights provisions in national constitutions than by specific legislation. 4.31. Australia does not have a constitution that addresses human rights. Fundamental rights and freedoms in this country are guaranteed more through values inherent and practiced in our parliamentary system of democracy. And over the page, the fact that these rights are not expressed in written form, of course, could lead to government excesses, though the courts are particularly vigilant in protecting the rights and freedoms traditionally associated with our unique style of parliamentary democracy. This protection is manifest in court-based rules, which include rights to be informed and rights to be allowed to make representations when legitimate interests and expectations are about to be affected. I'll just stop some comments on that chapter or that section. We don't, of course, have a Bill of Rights in Australia, as is the case in many other jurisdictions. I guess it's an interesting topic that we see often in subjects like introduction to law, whether we ought to have a Bill of Rights, whether it's necessary. But you'll see there, in terms of the question of separation of powers, the comments made by Bates quite correctly that there is a danger without a Bill of Rights that Parliament could legislate to excess and impinge upon the rights and freedoms that people have, but courts exercise their power uniquely, I guess, independently, to ensure that the government or the Parliament does not create laws which encroach unfairly into the legitimate rights of individuals. So the courts provide something of a protection in that regard. All right, does anyone wish to make any comments about what I've said?
It's Don Naylor here, John. I'm just wondering whether this, the human rights issue, comes up a lot with the immigration policy, and is it they sort of pushing the envelope because we don't have a constitution, or in the constitution, an actual human rights? They tend to be sort of pushing the envelope a little bit and using that as a ploy to put their policies through in the way they want to run their policies.
Look, I guess so. I guess all of that is covered through international treaties and conventions and those other sources of international law. But yeah, you're right. There is no constitutional basis which can be relied upon in protecting rights and freedoms in a general sense. So I don't want to comment too much about that topic, but I understand what you're saying.
Political correctness, John.
All right. Any other comments or questions? Let's move on to 4.32, which deals with global trade and environmental protection. Environment protection and exhaustion of natural resources are issues that are cut across the global principle that world trade should basically be free and without constraints. That's an interesting comment because that has some parallel to the position of environmental law generally in a domestic setting. And I've made the comment before, I think, that with the introduction of environmental law, it's had to, in many ways, cut across, to use the same term that Bates uses there, the rights of individual landowners in Australia. So, for example, in a domestic setting, environmental law may prescribe that certain people who own land are subject to certain obligations or constraints which weren't they weren't subject to prior to the introduction of environmental legislation. So we see a parallel here in the global sense, where environment protection are issues that cut across principles that world trade should be free and without constraint. World trade rules are administered through the World Trade Organization, WTO, and the principal treaty is GATT, the General Agreement on Tariffs and Trade. There's reference there to 1994 and the Committee on Trade and Environment, CTE, which is obviously aware and mindful of the potential of multilateral environment conventions to conflict with GATT rules. And over the page, a principle of international law is that if all parties to a treaty conclude a more specialised treaty, the provisions of the latter prevail over those of the former. And that's a principle that I've just highlighted because that's a general principle of law in any event, even in a domestic situation, that all things being equal, if you have a more specialised or more specific law, it will generally prevail over a more general law. And that's particularly the case if the more specific law is enacted after the more general legislation. Right, so any questions about that? Now, I'm not going to go into the extensive commentary which you see in relation to GATT, pages 116 through to 121. I'll leave you to read that for yourself if you wish. But I will
John,
go.
the issue that I did have with some of that and the GATT stuff is what happens, and I couldn't, to me it looked like that we were contravening that law when it comes to import of food goods or living organisms that can pass on, that act as vectors for disease or whatever in this country.
Sure.
It seems that customs in a spot of bother with that particular law. Is that correct? Am I reading that incorrectly?
Yeah. Was there anywhere particularly in the text that gave you that thought? Are you able to point to that?
I was just comparing it to, looking at the states and whilst they used a different technique where they were talking about dolphin-free tubes, so they were using it as a protectionism. Well, it appeared to me that they were using it as protecting their own goods.
Yes.
And especially in the dolphin case, and then again in the turtle case.
You're
However,
talking about the United States. Yep.
The US, sorry, yes. However, I was trying to sort of compare that to us. And if it's meant to be free trade, what actually happens in a situation like when we had, a few years ago when Cyclone Oswald came through and we didn't have bananas for 9 months, and there was a massive push to bring in international bananas, and the rest of the world wanted to bring in international bananas, but customs was saying it won't happen, and the DPI was saying it won't happen because there is a particular banana blight that is not actually in this country. If those countries were so inclined, could they actually internationally prosecute by saying that that's against the trade agreement?
Probably not, because the federal government does have power to make legislation in relation to issues such as quarantine. And Bates does make reference to the Quarantine Act of 1908, which restricts imports as a result of compelling scientific evidence. I think that would be more regarded as a domestic issue for the Commonwealth government to make, and realistically that could only be resolved, I think, through negotiation or trade conventions rather than through prosecution.
Okey-doke.
Thanks, Nikki. Any questions or comments? All right. Look, let's move on to paragraph 4.43, which deals with the influence of international law in Australia. As we said from the outset, international law does not have automatic application in Australia. To be effective in this country, international law must be translated into Australian law by domestic legislators. That's the same point we made before. However, there is very little federal environment law that does not spring from international obligations. And if you look to page 137, which is a few pages ahead, you'll see table 5.12, which shows the treaty-based sources of Commonwealth legislation, and the details are spoken about later. So you'll see the Commonwealth Act and the treaty from which it became effective. Well, sorry, not became effective, but the treaty which dealt with the issue. And from our purposes, the Environment Protection and Biodiversity Conservation Act, 1999, is based on the Convention of the World Cultural and Natural Heritage and other pieces of legislation. I'm sorry, other treaties rather. All right, now back to 4.45. Not all international obligations or matters of concern do find their way into domestic law. Climate change and management of the greenhouse gases, says Bates, are good examples. 4.47. A court or tribunal might be influenced by principles of international law and policy, even in the absence of any direct recognition in a particular domestic law in front of it. And again, it's a point we made before. The example given by Bates is Leach against National Parks and Wildlife Service. That's a New South Wales decision, where the Land and Environment Court in New South Wales, that's at a district court level. We call it the Planning and Environment Court, sorry, in Queensland, adopted the legitimacy of the precautionary principle as a means of decision-making, even though the legislation in question neither referred to the principle or required such an approach. So we've talked about the precautionary principle before as being something which is gaining status, where it is becoming a principle which is likely to be adopted as a result of its overwhelming acceptance through the international community and otherwise. The other example that we talked about in that context was the principle of sustainable development.
Excuse me, John.
Yes,
does that mean that you know, like they have to conduct research before they start a development, or
yes.
You know, take precautions?
Yeah, very much so. That's more in the planning law context, but yes, increasingly so. Things like environmental impact assessments are required to determine the environmental implications of developments generally. And there's a whole range of systems that are now effective in terms of the strategic level down to the more operational level in planning policies and planning documentation generally. But that does include dealing with environmental impacts, yes. Thank you, Lawrence. What I propose to do now, unless there's any objections, is to move on to Chapter 6 of Bates. This is still, I'm sorry, Week 4 material, dealing with the nature of environmental law, even though we're in Week 5. So if we could look at Chapter 6. Now this deals with pages 185 to 217 inclusive. The heading is Environmental Legislation, the purpose, the structure and the content. 6.1. The scope and content of environment law falls largely within the category which lawyers term as public law. Only specific legislation can effectively create and authorise government regulatory authorities and personnel to implement and enforce the law. Regulators have no inherent power to do anything. And that comes back to that concept of separation of powers, where we have regulators, the executive, who are able to act, but only if given specific legislative power to do so. They have no inherent power, it must be conferred upon them. The function of the courts is to interpret these statutes and make sure that the regulators only act within the boundaries of the legal authority conferred upon them. Decisions of regulators may also sometimes be tested through appeals on the merits of decision-making to specialised environmental courts or administrative tribunals, that is, whether the decision was appropriate rather than whether it was lawful. So there's been some discussion on Moodle about merits appeals. So you can see that a merits appeal is a decision as to whether is a decision made by a tribunal or court to determine whether an executive decision which had been made was appropriate. That's opposed to, say, judicial review, which deals with the question of whether it was lawful. Judicial review and merits appeals are dealt with in Chapter 20, but the purpose of this chapter, says Bates, is to consider how environmental policy is translated into law and how regulators are empowered and instructed to implement policy directions and initiatives. The purpose of environmental law. Now, is there any questions before I move on, or comments? Okay. So the purpose of environmental law, 6.2, the purpose is to protect the social values enshrined in society, give legal effect to the policies of government, and the dominant social value espoused by our system of government is capitalism. So it's no surprise to find that law and policy relating to environmental management traditionally supports the economic utilisation of natural resources. This concentration on rights of exploitation, however, has meant that the law initially developed with little sense of environmental values and with little appreciation of the necessity for sustainable management of land and other natural resources. Environmental law in Australia is therefore primarily legislation that is designed to give expression to policies of government in relation to sustainable management of all forms of natural resources. Now, the reason I've read that section in full is that I think it's a terrific outline of what environmental law is designed to deal with, and that is, we talked about it before, cut across the rights which are at law inherently conferred upon owners of real estate. In dealing with environmental legislation, Bates makes reference to the national competition policy. That's at 6.4 and 6.5. And he makes the comment that environmental law does restrict and place conditional limitations on access to public natural resources. It does limit what the owners of private assets may do in relation to the use and exploitation of those assets. Therefore, environmental regulation cuts across national competition policy. And national competition policy aims to deliver improved economic efficiency, including the removal of regulatory impediments to productivity. So the clash there between environmental law and the NCP is that environmental law is creating regulatory impediments to productivity. So there's therefore a clear clash potentially between those two principles. At 6.5, Bates cites a good example is product stewardship or extended producer responsibility, in which producers and suppliers take full responsibility for the reuse, recycling, or disposal of their products after the product has effectively become no longer usable to consumers. Product stewardship effectively influences the design of products by making manufacturers think about how they're going to deal with a product for which they must now take full life cycle responsibility. So environmental law imposes obligations which go beyond what had been the case previously, where there was no ongoing liability by a manufacturer for the product in terms of environmental concerns. Any questions, comments? All right. I'll move on to 6.7, which deals with the structure of environmental law. And there are 4 sections in this regard through pages 189 to 205. The first, A, well, let's call it, deals with definitions of environmental law, which commences on page 190. B, different legislative regimes that may apply to the same activity, which is on 194. C, the objects of legislation, 198. And D, statutory functions, which is on 203. So we'll just go through, deal with those 4 things. Firstly, definitions in environment law. 6.11. Where the legislation does not define a word or phrase, then the court will adopt the ordinary everyday meaning unless there's good reason why it should not. At 6.12, a grammatical or literal approach will therefore be a starting point, but may be abandoned where such an interpretation does not conform to the legislative intent ascertained from the provisions of the statute as a whole. We see that a lot in planning law, where planning regulatory authorities might specify, for example, that residential development may be permitted in a certain zone. But when one looks at the entire policy, it might be, for example, in dealing with the survival of koalas in a certain habitat, it might be clear that the legislative intent is to ensure that koala habitats are maintained, and therefore a particular development might be rejected, or an application for development for housing might be rejected, not because of the literal words, but because of the overall reading and determining the legislative intent as a result of the policy in question. I hope that's not too confusing. Any questions there? Right, at 6.13, the objective intention of the legislation is what the courts are trying to ascertain, and this may depend upon the context. At 6.14, a strict grammatical approach to interpretation may not properly give effect to the purpose. The meaning may require consideration of the context, which includes the general purpose and the policy of a provision, in particular, the mischief it is seeking to remedy. When we talk about the mischief, that has a particular legal context. In Introduction to Law, Statutory Interpretation, sometimes we try to determine or interpret legislation by reference to what we call the mischief that it's trying to remedy. And quite often that means having a look at the introductory notes to the legislation, maybe even going back to Hansard and considering the arguments before Parliament which led to the introduction of that legislation. At 6.15, if the meaning of a statutory provision is ambiguous or obscure, then the Acts Interpretation Act, or one of them, may give the court power to refer to extrinsic materials, that is, material not contained in the statute itself. For example, the Act may say that in interpreting domestic legislation, it may be appropriate to consider the international treaty from which it was drawn. Now, B, different legislative regimes may apply to the same activity, and this is 6.16. In law, there is no inherent conflict in having numerous pieces of legislation apply to the same activity, but questions arise as to how those various provisions are intended to operate. At 6.17, this can obviously lead to problems where provisions for conservation protection come up against provisions allowing damage, or destruction. Over the page, general powers to remove vegetation for management purposes could be construed as being constrained by specific powers to protect. And over the page again, at the tail end of 618, only in the event of irreconcilable conflict will the courts have to determine the hierarchy of provisions. The courts may have reason to determine that a Commonwealth law overrides a state law, that's section 109 of the Constitution, or that a later statutory provision must be intended to override an earlier one, we talked about that earlier tonight, or that an explicit statutory power must be intended to have priority over a general provision, and we talked about that earlier tonight as well. All right, so that's all I wish to say about different legislative regimes applying to the same activity. If I may move on to Part C in this general heading, which is the objects of legislation. At 621, Interpretation Acts throughout Australia commonly state that in the interpretation of a provision, a construction that would promote the purpose or object underlying the legislation is to be preferred to a construction that would not promote that purpose or object. And we talked about that before as well, in looking at what is the reason this legislation came into effect. What is its purpose? What is Parliament trying to achieve? The courts will interpret the legislation where possible, if there's an ambiguity, consistently with the perceived purpose or object. The example given, which is at 6.22, is Blue Mountains Conservation Society against Director General National Parks and Wildlife, where a ministerial approval for filming within a wilderness area of a national park was held to be invalid because the approval did not promote any management purpose or objective of park management. Indeed, by excluding the public while filming was in progress, an objective of the park was effectively denied. So that's where the court looked at the decision made by the minister, overturned it because it didn't promote an activity which was named as being important for that particular matter. Now, moving ahead to 6.27, another case by way of example, Director General, Department of Environment, Climate Change and Water against Venn, 2011, New South Wales. The court said that in order to remedy a breach of the Parks Act, should seek to achieve the objects of the Parks Act by applying the principles of ecologically sustainable development, including the polluter pays principle. In the next paragraph, instructions that require decision makers to seek to further or pursue or give effect to or achieve objectives may be regarded as imposing stricter or more focused duties of compliance or achievement than a mere instruction to have regard to objectives. So the point I'm trying to make there, I guess, which Bates is making, is that you need to look at the precise words and determine the degree to which the legislature is requiring the executive to deal with issues. Is the legislation requiring the executive to simply have regard to certain objectives, or do they want the executive to go further? And words such as achieve or give effect to or pursue are stronger and therefore stricter. Over the page at the tail end of 6.28, specific powers conferred on decision makers by legislation may also be interpreted to override more broadly expressed objectives. The case there given by way of example is Rosemount against the Minister, where the court held that a declaration of a state environmental planning policy by a minister held unlawful a declaration that had been made by the minister because it had not countenanced public opinion and therefore had not complied with the object of the Act. The Court of Appeal reversed the decision because of an inclusion in the Act of a specific power that enabled the minister to effectively override the general object of public participation. Now, I hope that's not too confusing, but what we're really saying is that generally speaking, the minister must regard public opinion. At first instance, the court said that the policy was wrong because he didn't, but on appeal, the court said the minister was right because he or she had specific power under legislation to override that general object of public participation. I'll move on to Part D in this section, which is Statutory Functions, and at 6.32 make this comment, or Bates makes this comment: statutory functions may be regarded as either mandatory or discretionary. Statutory duties are marked by such phrases in legislation as the authority must or shall, so that's mandatory, but where it's discretionary, they'll often use the word may to determine that they don't have to. So that's the difference between what lawyers call mandatory or discretionary. At the tail end of 6.32, decision-making under statutory schemes is subject to the principles of judicial review to determine whether duties or powers have been exercised in a manner which conforms with legal standards for decision-making. And there's commentary on that at Chapter 20. At 6.33, criteria for decision-making may be of general application or may be specifically drawn for a particular purpose within the scheme. One of the most common generic criteria for decision-making in environmental law is the requirement to have regard to the principle of ecologically sustainable development. And that's referred to in Chapter 7. It is, however, common for legislation to require decision makers to apply specific criteria to the exercise of particular powers, for example, in relation to allocation of rights. Now, you've all been very patient, and I know this is a little dry, but I think it's still pretty interesting. Are there any questions or comments based on what I've said? We're about 5 minutes away from completing Chapter 6, which would take us to the end of the work required for week 4. So I propose to do that if I may. The heading Instruments of Environmental Management, 6.34. The comment is made that an important purpose of legislative schemes for environmental management is to confer powers on authorities to create and use a wide range of tools. Some of these tools may be mandated by legislation, such as instruments of strategic management. Others are discretionary and may be employed if the government regulator judges it to be appropriate. At 6.36, there's commentary in relation to project evaluation and licensing, and it's common in all natural resource management and environmental protection legislation to allow a competent authority to permit by license activities that legislation would otherwise make unlawful. Comment is made, and this is important, that licensing is the backbone of environmental law. Licenses are commonly required to develop land or emit pollution or take native or endangered wildlife. But as a matter of law, conditions on licenses must fairly and reasonably relate to the activity. Before a license can be issued, some form of assessment needs to be made, and that's at 6.37. And that's similar to a comment that I think you made earlier, Lawrence. 6.38, a statutory license is a legal arrangement between the people entitled to utilise a resource and the authority empowered to control access to the resource. Licensees generally view their entitlement as conferring on them a right more akin to property. For example, a person given a license to take commercial quantities of fish may regard that as an entitlement able to be traded quite separately from any particular fishing boat or person. At 6.39, fishermen may now be given not just a license to take commercial quantities of fish, but may be able to trade that share for the value of that fishery. We then have some comments in relation to market-based instruments at 6.40. Legislation focuses now on complementing regulatory approaches with economic incentives. Others go beyond compliance to voluntarily continuing to improve performance. In other words, at 6.41, there's reference made to a carrots and sticks approach. All right, well, you've been very patient, thank you. I'll just simply leave you tonight with the conclusion which is drawn by Bates, and this is at page 217, where he says, ultimately, achieving beneficial environmental results comes down to a comprehension that social and economic expectations cannot be realised without a demonstrable commitment to best practice environment management. Okay, that concludes the material for week 4. There's a break next week, and what I propose to do is return in week 6 in dealing with the material in relation to the Commonwealth's role. So at this stage I'm 1 week behind, but we will catch up. So are there any questions before I close? All right. Well, thank you very much for your patience. I know there's a lot of reading material, but keep up the good work. All the best.